Swayam Prabha. Digital India. Educated India.
Hello everyone, this is Dr. Shabnam Mehlawat from the University of Delhi, Faculty of Law. I will today now be starting with the Indian laws and the right to constitutional remedies, which are accomplished with the help of the National Green Tribunal, which came into force in the year 2010. India did not have a specific tribunal to decide cases or a specialized body where a decision in relation to environmental cases would be taken up separately. It was only in the year 2010 that the government previously, a few years back, thought of setting up a tribunal or an adjudicating body which would help in deciding cases only with relation to environment. So the background of the setting up of the National Green Tribunal was, with many cases which were decided by the local courts, the High Court and the Supreme Court, they felt the need to have a specialized agency whereby environmental cases could be tried separately. So it was in the case of MC Mehta versus Union of India, the Indian Council for Enviro-Legal Action versus Union of India, wherein environmental degradation took place by an industry which was producing chemical waste and dumping that waste deep into the ground, where it got percolated into the drinking water and it polluted the area. The other case was the Andhra Pradesh Pollution Control Board versus Professor M.V. Naidu, where they wanted to set up a hazardous industry within the 10-kilometer radius of the two cities, which were Hyderabad and Secunderabad. These cities had twin lakes, and if the industry was allowed to set up there, and if pollution was created, it would pollute the water which was being sent to the two cities for the purpose of drinking. So it was these cases, that environmental cases, they involved frequent assessment of scientific data, setting up of environmental courts on a regional basis with a legally qualified judge, two experts who would help to speed up the judicial process. The Law Commission of India, in its 186th report 2003, recommended the establishment of environmental courts in India. This recommendation was based on a review of the technical and scientific problems that came before the courts and the inadequacy of the judicial knowledge and on the scientific and technical aspects of environmental issues. It was then the Environmental Appellate Authority Act 1995 and the same act in 1997 which proposed the setting up of a separate adjudicating body for the trial of environmental cases. Then came the international soft law and hard law for access to justice by court and tribunals. The tribunal, which is the NGT, was established with the purpose of speedy disposal of environmental cases for its protection, whereby enforcement of legal rights may be ensured by providing compensation for damages to persons and property and matters which are incidental to the main issues. It is in consonance with the principles of the Stockholm Declaration 1972. The NGT sought to follow the principles which were so advocated under the said declaration. There were 26 principles in all, as I have stated in my previous slides, which followed the principle in adapting to access to justice and for its purpose for the environmental protection and conservation of our natural resources. It was in the Rio Summit in 1992 which ensued, which called for an effective access to judicial and administrative proceedings, including redress and remedy, and to develop national laws regarding liability and compensation for the victims of pollution and other environmental damages, which is the basis for why NGT was formed, and the decision which would be based on scientific and technical data along with other experts experts who would guide the way for a proper settlement of the cases. Adhering to the right to a healthy environment under Article 21 of the Indian Constitution, it is a fundamental right which encloses within it all environmental rights wherever they are violated, whether of the people, of the environment, or wherever it relates to. The scope of Article 21 has been expanded to include environmental rights, that if anybody's right to a healthy living is taken away, then Article 21 can be specifically enforced to enforce those fundamental right of a healthy living. And it also places the fact that no person can take away those rights except for the due procedure established by the law. So, creation of pollution is not the due procedure, hence these rights fall under Article 21. For all environmental related issues, the National Green Tribunal was established in the year 2010. Now, defining the various terms under the Act was so defined so as to it is an open-ended law to define, to explain the powers of the body which has been set up, the appellate authority which has been set up, their power to decide on compensation, their power to decide on penalties which might be placed on these industries or occupiers who are trying to create pollution or are involved in projects which might be detrimental to the environment. So, with respect to that, the first incident which comes to the mind is the Bhopal disaster. It was an accident which took place whereby the laws were not in place, the adjudicating bodies were not aware, and they did not really know how to start the case and decide the case. So, it took a lot number of years to decide what was the Bhopal disaster and how it should be dealt with. This Act defines accident which involves fortuitous or sudden or unintended occurrence while handling any hazardous substance or equipment or plant or vehicle resulting in continuous or repeated exposure to death, injury, person, damage to any property or environment, but does not include an accident by reason of a war or civil disturbance. The chairperson, he is the person who is appointed as a chairperson of the National Green Tribunal. The definition of environment is given as a very broad definition to include all kinds of species and all kinds of natural resources which are considered in the definition of the word environment. It includes water, air, land, and the interrelationship between the three, which exists amongst the water, air and land and human beings, other living beings, plants, microorganisms and property. The handling means any hazardous substance means the manufacturing, process, treatment, package, storage, transportation, use, collection, destruction, conversion, offering for sale, transfer or the like of such hazardous substance. Hazardous substance means any substance or a preparation which is defined as hazardous under the Environmental Protection Act 1986 and the exceeding of such quantity as is specified or may be specified by the central government under the Public Liability Insurance Act 1991. So, what is an injury? Injury includes what is a permanent, a partial or a disablement of sickness resulting out of an accident. So, whenever an accident takes place, somebody gets impaired or a detrimental effect comes to that person, he is said to have been injured. A person, now that is a very important definition because it goes to include a whole categories of people who might be described as a person or persons. It includes an individual, a Hindu undivided family, a company, a firm, an association of person or a body of individuals, whether incorporated or not, a trustee of a trust, a local authority, and every artificial juridical person not falling within the preceding sub-clauses. The substantial question relating to environment shall include where there is a direct violation of a specific statutory environmental obligation by a person by which the community at large, other than an individual or group of individuals, is affected or likely to be affected as a part of the environmental consequence. The gravity of damage to the environment or property is substantial. The damage to public health is broadly measurable, and the environmental consequences relate to a specific activity or a point of source of pollution. The words and expressions used in this act but not defined are, which are those defined under the Water Act 1974, the Water Cess Act 1977, the Forest Conservation Act 1980, the Air Pollution Act 1981, the Environmental Protection Act 1986, the Public Liability Insurance Act 1991, Biological Diversity Act 2002. These are acts which relate to environment and have the same meanings assigned to them in these acts. So, environment includes a broad term which includes all natural resources as well as all living persons, people, animals, plant life, microorganisms, whatever is in a living form is all considered a part of the environment. Then comes the establishment of the tribunal. In 2010, there were 40 countries across the world who wanted to establish a special body in relation to trial of cases for environment. So this led to 40 nations establishing special legislations within the domestic domains of their countries, including India, which led to the establishment of the tribunal. Under Section 3 of the Act, it talks about the jurisdiction, the powers and the authority which are conferred on the tribunal under this Act. Section 4 talks about the composition of the tribunal. This is very important for any person to know that how many members are constituted in this tribunal for the trial of their cases. This includes a say by most of the people who would be legal members, who would be experts in their field, or who would have special knowledge in relation to a case. These persons may be appointed as members. Looking at the category which has been specifically defined under the Act are a full-time chairman, members not less than 10 but subject maximum to 20 full-time judicial members of the central government may from time to time notify. Then not less than 10 but subject maximum to 20 full-time expert members as the central government may from time to time notify. The chairperson of the tribunal may, considered necessary, invite any one or more than one person as having specialized knowledge and experience in a particular case before the tribunal to assist the tribunal. The central government may, by notification, specify the ordinary place or places of seating of the tribunal and the territorial jurisdiction falling under each place of seating. The central government may, in consultation with the chairperson, make rules regulating generally the practices and procedure of the tribunal, including the rules as to which persons are entitled to appear before the tribunal, the rules as to the procedure for hearing applications, appeals and other matters, including the circuit procedure for hearing at a place other than the ordinary place of sitting falling within the jurisdiction referred to in subsection 3. It pertains to the application and the appeals, the minimum number of members who shall hear the applications and appeals in respect of any class or classes of applications and appeals, provided that the number of expert members in hearing an application or appeal be equal to the members which are judicial members hearing such application or appeal, the rules relating to transfer of cases by the chairperson from one place of seating to other place of seating. So, there are 5 places all over in India currently where the tribunal holds its offices, which has the central place in Delhi for the trial of these cases. Now, what will be the qualification of the members of the board? The qualifications require a person shall not be qualified for appointment as the chairperson or a judicial member of the tribunal unless and until he has been a judge of the Supreme Court of India or a Chief Justice of the High Court in India, and provided that a person who is or has been a judge of the High Court shall also be qualified to be appointed as a judicial member. A person shall not be qualified for appointment unless for an expert member, unless he has a degree in Masters of Science or in Physical Sciences or Life Sciences with a doctorate degree or Master of Engineering or Master of Technology and has an experience 15 years in the relevant field, including 5 years practical experience in the field of environment and forests, which includes pollution control, hazardous substance management, environmental impact assessment, a climate change management, biological diversity management and forest conservation in a reputed national level institution, or has administrative experience of 15 years, including experience of 5 years in dealing with environmental matters in the central or the state government or in a reputed national or state level institution. The chairperson, the judicial members and the expert members shall not hold any other office during their tenure when they are appointed in the National Green Tribunal. The chairperson and other judicial and expert members shall not for a period of 2 years hold office except any employment connected with the management or administration of any person who has been a party to a proceeding before the tribunal under this act. Now, this is violative of the rights of natural justice, that a person cannot be a judge in his or her own case. So, if they have tried a case previously and they are appointed here dealing with the case, then they have to be replaced by another member, since they cannot deal with the same issue twice. Now, the proviso says that provided nothing is contained in this section shall apply to any employment under the central government or a state government or a local authority or in any statutory authority or any corporation established by or under any central, state or provincial act or a government company as defined in section 617 of the Companies Act 1956. The appointment of the board members, these the chairperson, the judicial members and the expert members as given under section 5. They shall be appointed by the central government. The chairperson shall be appointed by the central government in consultation with the Chief Justice of India. The judicial members and expert members shall be appointed on the recommendations of a selection committee and in such a manner as may be prescribed under their rules and regulations. The terms and conditions governing the members are: the chairperson, judicial members and expert members shall hold office for a term of 5 years from the date on which they enter the office, but shall not be eligible for reappointment, provided that in such a case a person who is or has been a judge of the Supreme Court has been appointed as the chairperson or judicial member of the tribunal. He shall not hold office until he has attained the age of 70 years. Provided further that in case of a person who is or has been appointed as the Chief Justice of a High Court, has been appointed as chairperson or judicial member of the tribunal, he shall not hold office after he has attained the age of 67 years. Provided also that in case a person who is or has been a judge of the High Court has been appointed as a judicial member of the tribunal, he shall not hold office after he has attained the age of 67 years, provided also that no expert member shall hold office after he has attained the age of 65 years. The resignation: the chairperson, judicial members or expert members of the tribunal may, by a notice in writing, hand over their resignation to the central government and may resign from their office for whatever reasons known to them, or they may specifically ask for a resignation on a specific ground for which they shall be granted that, for which the post shall fall vacant. The salaries, allowances and other terms and conditions of service include: they may be prescribed previously or according to certain rules and regulations, and neither the salary or allowances nor the other terms and condition of service of the chairperson, judicial members and expert members shall be varied to their disadvantage after their appointment. The conditions of removal of such members: they may, after they have been appointed, they may also be removed from their office for certain reasons which are given under the Act, which is under section 10. It describes as: the central government may, in consultation with the Chief Justice of India, remove from the office the chairperson, judicial members, where they have been adjudged and insolvent, they have been convicted of an offence when the opinion of the central government involves moral turpitude, have become physically or mentally incapable, have acquired such financial or other interests as is likely to affect prejudicially his functions, has abused his position and renders his continuance in office prejudicial to the public interest. The chairperson, judicial member shall not be removed from his office except by an order made by the central government after an inquiry has been made by the judge of the Supreme Court, in which such person, judicial member, has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. The central government may suspend from office the chairperson, judicial members, in respect of whom a reference of conducting an inquiry has been made to the judge of the Supreme Court under subsection 2 until the central government passes an order on receipt of report of inquiry made by the judge of the Supreme Court on such reference. The central government may, by rules, regulate the procedure of inquiry referred to under subsection 2. The expert member may be removed from his office by an order of the central government on the grounds of subsection 1 and in accordance with the procedure as may be notified by the central government, provided that the expert member shall not be removed unless he has been given an opportunity of being heard in that matter. This too conforms with the principles of natural justice, that you cannot convict a person unless he has a say in the matter. He is given an opportunity to explain himself as to why he should not be punished or why he should not be removed. The conditions related to members and staff of the board will be qualifications, terms, conditions of these persons. They are appointed after the commencement of the Tribunal Reforms Act 2021 shall be governed by the provisions of Chapters 2 of the said Act. The chairperson, judicial members and expert members appointed after the commencement of Part 14 of Chapter 6 of the Finance Act shall continue to be governed by the provisions of that Act and the rules made thereunder, as if the provisions of Section 184 of the Finance Act has not come into force. To act as the chairperson of tribunal or to discharge his functions in certain circumstances, in the event of occurrence of any vacancy in the office of the chairperson of the tribunal by reason of his death, resignation or otherwise, such judicial member of the tribunal or as the central government by notification authorized in this behalf shall act as the chairperson until on the date on which a new chairperson is appointed in accordance with the provisions of the Act. The staff of the tribunal. The central government shall determine the nature and categories of officers and employees required to assist the tribunal in the discharge of his functions. The recruitment of the officers and other employees of the tribunal shall be made by the chairperson in such a manner as may be prescribed. The officers and other employees of the tribunal shall discharge their functions under the general superintendence of the chairperson. The salaries, allowances and conditions of service of these officers and employees shall be as may be prescribed by the tribunal. The financial and administrative powers of the chairperson. The chairperson shall exercise financial and administrative powers as may be vested in him under the rules made by the central government. The chairperson may delegate such powers as he may think fit to any judicial member or expert member or officer of the tribunal, subject to the condition that member officer, while exercising his power, continues to act under the direction, control and supervision of the chairperson. Then comes the jurisdiction, powers and proceedings of the tribunal. The earlier part was setting up of the tribunal, appointment of persons who will be forming the panel for deciding the cases, their qualifications, their disqualifications and the terms and conditions of service by which they are appointed on that position. Now comes the powers and proceedings of the tribunal. The powers of the tribunal include deciding disputes, it also involves those powers which are detrimental to environment, so which lead to the shutting down of industries, ask them to pay penalties and to punish them in case it is so required, in case they are committing repeated pollution in those areas. So the tribunal is to settle disputes. It shall have jurisdiction over all the civil cases where a substantial question related to environment is involved. It includes enforcement of any legal right in relation to environment, and such question arises out of the implementation of the enactments specified in Schedule 1. The tribunal shall hear the disputes arising from the questions referred to under subsection 1 and settle disputes and pass orders thereon. No application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months from the date on which the cause of action arose of the said dispute. So the tribunal may, if it is satisfied the applicant was prevented by sufficient cause from filing the application within the said period, allow it to file within a further period not exceeding 60 days. So, he is given a time period of 60 days to file a case when a cause of action arises, and in case he can provide due reasons of not filing that case within those 60 days, another 60 days are given as a power of the tribunal to consider that it is a reason enough to give him more time to file his case. Then comes the relief, compensation and restitution. The tribunal may, by an order, provide relief and compensation to the victims of the pollution and other environmental damages arising under the enactment specified in Schedule 1, including accident occurring while handling any hazardous substance, for restitution of property which is damaged, for restitution of environment of such area or areas as the tribunal may think fit. The relief and compensation and restitution of property and environment referred to in the earlier 3 clauses shall be in addition to the relief paid or payable under the Public Liability Insurance Act 1991, which means there are separate headings for the payment of compensation and for payment of compensation not only to the people and the property to which damage has been caused, but also to those which require special attention because of the activity and have been specifically damaged because of the same. So, the relief and compensation of the environment referred to in it is in addition. No application for grant of compensation, relief or restitution or environment under this section shall be entertained by the tribunal unless it is made within a period of 5 years from the date on which cause for such compensation or relief first arose, provided that the tribunal may, if it is satisfied that the applicant was prevented by sufficient cause from filing the application within the said period, allow it to be filed within a further period not exceeding 60 days. So, that the same provision of 60 days applies again. The tribunal may, having regard to the damage to public health, property, environment, divide the compensation or relief payable under separate heads specified in Schedule 2 so as to provide compensation or relief to the claimants and the restitution of damaged property or environment as it may think fit. Every claimant of the compensation or relief under this Act shall intimate to the tribunal about the application filed to or the case as may be compensation or relief received from any other court or authority besides the tribunal. Then comes the appellate authority of the tribunal. Firstly is the original jurisdiction wherein the case is directly filed. Earlier, the procedure adopted used to be when a pollution or an accident took place, the person would file an application in the Central Pollution Control Board where they would decide the dispute. Then an appellate authority there would go in for deciding the appeals filed from the order made by the pollution board. After the appellate authority, it would then go to the lower courts or the high court depending on the territorial, pecuniary or other jurisdictions associated with the case. But after the passing of the National Green Tribunal Act 2010, after the decision has been made by the pollution control boards and their appellate authorities, the cases are now filed directly to the tribunal. So, it has both the original jurisdiction to try a case, and then when the decision has been made by the tribunal once, it goes into appeal of the appellate authority created specifically for the tribunal. So, this appellate jurisdiction involves where a person is aggrieved by an order or decision made after the commencement of the National Green Tribunal by the appellate authority under Section 28 of the Water Act, an order passed on or after the commencement of the National Green Tribunal by the state government under Section 29 of the Water Act, directions issued or after the commencement of the NGT by a board under Section 33A of the Water Act, which includes the shutting down also of any industry or the essential services associated with the industry if it is felt that they are committing certain hazardous pollution or persistently creating pollution and not stopping their activity despite repeated reminders. An order which is made on or after the commencement of the tribunal of the appellate authority under Section 13 of the Water Cess Act 1977, An order or decision made after the commencement of the NGT by the state government or authority under Section 2 of the Forest Conservation Act 1980. An order or decision made after the commencement of the NGT by the appellate authority under Section 31 of the Air Pollution Act 1981. And direction issued after the commencement of the NGT under Section 5 of the Environmental Protection Act. An order made after the commencement of the NGT granting environmental clearance in the area in which any industry, operations, or processes or a class of industries, operations or processes shall not be carried out or shall be carried out subject to certain safeguards under the Environmental Protection Act of 1986. If an order is made on or after the commencement of the NGT refusing to grant clearance for carrying out of any hazardous activity, an operation or a process under the Environmental Protection Act, any determination of benefit sharing, an order of the commencement of the NGT by the National Biodiversity Authority or the State Biodiversity Board under the provisions of Biological Diversity Act 2002 may, within a period of 30 days from the date on which such an order or decision or directions or determination is communicated to the person, he may prefer an appeal to the tribunal, and the tribunal, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period of 60 days, allow it to be filed further within a period not exceeding 60 days. So this includes the appellate jurisdiction of the tribunal to try those cases in appeal where people are aggrieved by the orders which have been passed below by adjudicating authorities below the tribunal. Then comes the compensation and relief for victims. The liability to pay relief or compensation in certain cases where death takes place, where injury is there, and where any person other than a workman or damage to any property or environment has resulted from an accident or an adverse impact of an activity or an operation or a process under any enactment specified in Schedule 1, the person responsible shall be liable to pay such relief compensation for the death, injury or damage under all or any of the heads specified in Schedule 2 as may be determined by the tribunal. If a death or injury or damage is caused by an accident or an adverse impact of an activity, operation or process under any enactment specified in Schedule 1, cannot be attributed to any single activity, operation or process, but is the combined or a resultant effect of several such activities, operations and processes, the tribunal may apportion the liability for relief or compensation among those responsible for such activities, operations and processes on an equitable basis. The tribunal, in case of an accident, apply the principle of no fault liability, which is absolute liability in Indian cases, to provide compensation when an accident, disaster takes place because of a procedure, because of a process, or because of an industrial activity which might be related to hazardous waste. This provision has specifically been incorporated after the Bhopal disaster, where the law was not in place to deal with the problem. Then comes the appeal to the tribunal. Application or appeal to the tribunal is under application under section 14 and 15 or an appeal under section 16 shall be made to the tribunal in such form it shall contain the particulars, be accompanied by the documents and the fees as may be prescribed. Without prejudice to the provisions contained in section 16, an application for grant of relief or compensation for the settlement of a dispute may be made to the tribunal by a person who has sustained the injury, the owner of the property to which damage has been caused, death has resulted from the environmental damage, all or any legal representatives of the deceased, any agent duly authorized by such person or owners of such property or of any legal representatives of the deceased as the case may be. Any person aggrieved, including any representative body or organization, the central government or state government or a union territory administration or the Central Pollution Control Board or a state pollution control board or a pollution control committee or a local authority or any environmental authority constituted or established under the Environmental Protection Act or any other law for the time being in force. provided that where all the legal representatives have not joined in such an application for compensation or relief, this application may be made on behalf of or the benefit of the legal representatives of the deceased, or the legal representatives who have not joined shall be impleaded as respondents to the application. Provided further that the person, the owner, the legal representative, the agent, the representative body or organization shall not be entitled to make an application for grant of relief or compensation or settlement of dispute if such person have preferred an appeal under section 16. The application, as the case may be, the appeal filed before the tribunal under this act shall be dealt with by it as expeditiously as possible, and endeavour shall be made to dispose of the application, or as the case may be, the appeal finally within 6 months from the date of filing of the application, or as the case may be, the appeal after providing the concerned parties an opportunity of being heard. What are the powers and procedures to be adopted by the tribunal? They shall not be bound by the procedure laid down by the Code of Civil Procedure, or the CPC as it is commonly referred to, but shall be guided by the principles of natural justice. They are subject to the provisions of the Act. They shall have the power to regulate their own procedure. They shall also not be bound by the rules of evidence contained under the Indian Evidence Act of 1872, which has currently now been amended and changed. So this is prior to the new law of evidence which is being passed in the year 2023, but they are all subject to the relevant laws, but not subject to the exact same procedure as is followed by the civil laws in our country, which is the Code of Civil Procedure and the Indian Evidence Act. This court shall have, for the purpose of discharging its functions, the same powers as vested in a civil court under the Code of Civil Procedure 1908 while trying a suit, in respect of the following matters, namely, which are summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of documents, receiving evidence on affidavits, subject to the provisions of section 123 and 124 of the Indian Evidence Act, requisitioning any public record or document or copy of such record or document from any office, issuing commissions for the examination of witnesses or documents, reviewing its decision, dismissing an application for default or deciding it ex parte, which means one-sided, setting aside any order of dismissal of any application or default or any other order passed by it ex parte, pass an interim order including granting an injunction or stay and providing the concerned parties an opportunity of being heard, or an application made or appeal filed under this Act. They may pass an order requiring any person to cease, desist from committing or causing any violation of any enactment specified in Schedule 1, any other matter which may be prescribed. So it is specifically giving out that the environmental laws are specifically dealt by courts in a civil procedure, which means the criminal liability is still left to be decided by the other courts. It is only the civil powers and the civil compensation which comes to in relation to environmental damages, that compensation is provided by means of monetary manner. All proceedings before the tribunal are deemed to be judicial proceedings within the meaning of section 193, 219 and 228, and for the purposes of section 196 of the IPC, and the tribunal shall be deemed to be a civil court for the said purpose, and chapter 26 of the Code of Criminal Procedure 1973. Then, decision of cases to be undertaken by majority of members based on the principles. After the procedure has been established, after the compensation factor has been decided as to how they will deal with the same, after the powers and functions of the tribunal and its officers has been decided, the next applicability is the principles as to how these principles are applied in the cases which are decided by the tribunal and its members. These are principles which relate to sustainable development, specifically the precautionary principle, which involves environmental impact assessment, which further involves creation of reports before you start a hazardous activity, and the reports to be looked into when disputes take place to see why environmental clearance was given to such products when specifically they are dealing with such activity. The other is when the industry or the waste has been created or damage has been placed for environmental pollution, the polluter pays principle comes into play, that the person who has created that pollution must be made to pay, and it is an absolute liability principle which says whether it was the person's fault or not, he is absolutely liable to pay for the compensation for the damage which his activity has caused to the people and the environment. This decision needs to be taken by the majority. The decision of the tribunal by the majority of members is binding. It provides that there is a difference of opinion among the members hearing an application or appeal, and the opinion is equally divided. The chairperson shall hear, if he has not heard earlier, such application or appeal and decide, provided further that the chairperson himself has heard such application or appeal along with the other members, and if there is a difference of opinion among the members in such cases and the opinion is equally divided, he shall refer the matter to other members of the tribunal, who shall hear such application or appeal and then decide the case. The final appeal is to be made then to the Supreme Court. So, section 22 says, after a case has been decided by the tribunal, including its appellate authority, and a decision has been made by the tribunal or an award and order has been sent out, the final appeal now then goes to the Supreme Court by the aggrieved person from those decisions for the case to be tried and finally decided. So, the appeal to Supreme Court involves any person who is aggrieved by an award, decision, order of the tribunal may file an appeal to the Supreme Court within 90 days from the date of communication of the award, decision or order of the tribunal to him, or to any one or more of the grounds specified in section 100 of the Code of Civil Procedure, provided that the Supreme Court may entertain any appeal after the expiry of 90 days if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal. So, these timelines give the courts and the tribunals the power to decide or the power to give leverage to the plaintiff or the aggrieved persons, whosoever it may be, to allow them to file their cases if they are aggrieved by the decision of certain authorities. The costs and deposits for damage to the environment. The cost while disposing of an application or appeal under this Act, the tribunal shall have the power to make such order as to costs as it may consider necessary, where the tribunal holds that the claim is not maintainable or is false or vexatious, and such claim is disallowed in whole or in part, the tribunal may, if it so thinks fit, after recording its reasons for holding such claim to be false, vexatious, make an order to award costs in lost benefits due to any interim injunction. Interim injunctions are those where when the case is being decided, in the middle of the case, the court may order the stopping of an activity in the middle of the proceedings, and after it has been decided, then carry the case further till the final decision comes out in the case. So, the deposit of amount payable for damage for environment, where any amount by way of compensation or relief is ordered to be paid under any award or order made by the tribunal on the ground of damage to the environment, that amount shall be remitted to the authority specified under subsection 3 of section 7A of the Public Liability Insurance Act for being credited to the Environmental Relief Fund established under the said section. The amount of compensation or relief credited to the Environmental Relief Fund under subsection 1 may be, notwithstanding anything contained in the Public Liability Insurance Act, be utilized by such persons or authorities in such manner and for such purposes which relate to the environment as may be described or prescribed. The execution of award or decision of the tribunal. An award or decision of the tribunal under this Act shall be executable by the tribunal as a decree of the civil court, and for this purpose the tribunal shall have all the powers of a civil court, notwithstanding anything contained in this subclause 1, Tribunal may transmit any order or award made by it to a civil court having local jurisdiction, and such civil court shall execute the order or award as if a decree was made by that court. Now, we are not talking of a degree, but a decree. A decree means where in one of the questions or issues involving a case, the court may pass only an order in relation to one specific issue of the dispute. So, where the persons are responsible for the death or injury or damage to any person, property or environment against whom the award or order is made by the tribunal fails to make the payment or deposit the said amount as directed by the tribunal within the period so specified in the award order, then such amount without prejudice to the filing of complaint for prosecution of an offence under the Act or under any other law for the time being in force shall be recoverable from the said person as arrears of land revenue or of public demand. The penalty for non-compliance of orders of the tribunal. The penalties involved are whoever fails to comply with an order or award or decision of the tribunal, he shall be punished with imprisonment which may extend to 3 years, or with fine, or which may extend to 10 crore rupees, or with both, or in case the failure or contravention continues, with additional fine which may extend to 25,000 rupees per day during which such failure or contravention continues, after conviction for first such failure or contravention. The proviso further says that in case a company fails to comply with any order, award or decision of the tribunal under this Act, such company shall be punishable with a fine which may extend to 25 crore rupees, and in case the failure or contravention continues, the additional fine which may extend to 1 lakh rupees per day during which such failure or contravention continues after the conviction for first such failure or contravention. Nothing contained in the Code of Criminal Procedure 1973. Every offence under this Act shall be deemed to be non-cognizable within the meaning of the said code. Then comes the offences by the companies and the government departments. Firstly, offences by companies. Where an offence under this Act has been committed by a company, every person at the time the offence was committed was directly in charge of, was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offence and shall be liable and be proceeded against and punished accordingly, provided that nothing in this subsection shall render any such person liable to any punishment provided in the Act if he proves that the offence was committed without his knowledge or he had exercised all due diligence to prevent the commission of such offence. Notwithstanding anything contained in the previous one's subsection 1, an offence under the Act has been committed by the company, and it is provided that the offence has been committed with the consent, connivance, or is attributable to any neglect or any part of any director, manager, secretary or officer of the company, then such persons shall also be deemed guilty of those offence and be liable to be proceeded against and punished accordingly. The explanation part talks about what is a company. It means a body corporate and includes a firm or other association of individuals. A director in relation to a firm means a partner in a firm too. Then comes the offences by the government departments. Where a department of a government fails to comply with any order, award or decision of the tribunal under the Act, the head of the department shall be deemed guilty of such failure and shall be liable to be proceeded against for having committed an offence under the Act and punished accordingly, provided that nothing contained in this section shall render such head of the department liable if he proves the offence was committed without his knowledge or he exercised all due diligence to prevent the commission of such offence. Nothing contained in the previous first subsection, where an offence under the Act has been committed by the department of the government and it is proved that the offence has been committed with the consent, connivance or is attributable to any neglect on the part of any officer other than the head of the department, then such officer shall be deemed guilty of that offence and be liable to be proceeded against and punished accordingly. Then there is a bar of jurisdiction. The bar of jurisdiction means when a case is being tried with an authority, no other authority has the jurisdiction to try that case. No authority shall take up the parallel trial of that case where the case is already being tried in a separate court or an adjudicating body. So, with effect to the establishment of the tribunal, no civil court shall have jurisdiction to entertain any appeal in respect of any matter where the tribunal is empowered to determine under its appellate jurisdiction, which means this leaves the procedure outside the scope of the civil courts. Where a case or a decision has been made in relation to an activity by the Pollution Control Board, the case may then be filed directly to the tribunal. No other court, when the case is being tried in the tribunal, no other court shall have the jurisdiction to try this case. No civil court shall have jurisdiction to settle disputes or entertain any questions relating to any claim for granting any relief, compensation, restitution of the property damaged or environmental damage which takes place and which may be adjudicated upon by the tribunal, and no injunction in respect of any action taken or to be taken before the tribunal in respect of the settlement of such dispute or any such claim for granting any relief or compensation or restitution of property damaged or environment damage shall be granted by the civil court. So, all civil courts are barred from trying a cases when the case is specifically filed within the tribunal. The cognizance of offences. No court shall take cognizance of any offence under this Act except on a complaint made by the central government or any authority or any officer authorized in this behalf by that government. Any person who has been given notice of not less than 60 days in such a manner as may be prescribed of the alleged offence or his intention to make a complaint to the central government of the authority or officer authorized as aforesaid. No court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try an offence punishable under this Act. Then comes the miscellaneous provisions. Members and staff members of the tribunal are public servants within the meaning of the laws of our country. The chairperson, the judicial members, the expert members, officers and other employees are deemed to be public servants within the meaning of section 21 of the Indian Penal Code of 1860. There is protection of action which is taken in good faith. Protection of action taken in good faith means when even if the action is done with a good intention, it still results in harm or damage. Those actions which display the fact that action was being taken in good faith will be protected by the law. No suit or other legal proceeding shall lie against the employees of the central government or a state government or any statutory authority or anything which is in good faith done or intended to be done in pursuance of this Act or any rule or order made thereunder. No suit, prosecution or other legal proceeding shall lie against the chairperson, judicial member or expert member of the tribunal or any other person authorized by the chairperson, judicial member or expert member for anything which is being done in good faith, done or intended to be done in pursuance of the Act or any other rule or order made thereunder. So, this Act to have an overriding effect. The provision of this Act shall have effect notwithstanding anything inconsistent contained in any other law for the time being in force or any other effect. Overriding effect means if there is a law which is present and this law is present, this law will take precedence over the other law which may be existing in the same field. The power of the central government to make amendments. The power is given to amend Schedule 1. The central government by notification amends Schedule 1, including wherein any act enacted by the Parliament with the objective of environmental protection and conservation of natural resources or omitting any act already specified therein or on the date of publication of such notification, such act shall be deemed to be included or as the case may be omitted from Schedule 1. A copy of the notification proposed to be issued under subclause 1 shall be laid in draft before each House of the Parliament while it is in session for a total period of 30 days, which may be comprised in one session or 2 or more successive sessions. And if before the expiry of the session, immediately following the session or the successive sessions, both houses agree in disapproving the issue of notification, or both houses, the Lok Sabha and the Rajya Sabha, agree in making any modification in the notification shall not be issued as the case may be, or may be only issued in the modified form as is agreed by between both the houses. So there is then the power of the central government to frame rules. The rules may be with respect to persons who are entitled, the procedure of hearing, the minimum numbers of members, the transfer of cases of chairperson from one place of seating to the other, the selection committees which may be there, the salaries and allowances of persons, the procedure of inquiry which may be there, recruitment of officers may be there, their salaries and allowances may be there, the financial and administrative powers to be exercised by the chairperson may be there, and likewise here a list of provisions are given where the central government has the power to make rules with respect to certain aspects of the tribunal. The power to remove, it also involves the power to remove any difficulties which it may encounter in the application of the Act. The Schedule 1 includes Water Act, the Water Cess Act, the Forest Act 1980, the Air Pollution Act 1981, the Environmental Protection Act 1986, the Public Liability Insurance Act 1991, and the Biological Diversity Act 2002. Schedule 2 contains heads under which compensation or relief or damage may be claimed. Schedule 3 contains laws which have been amended for appeals, that is to the National Green Tribunal. The laws, when the tribunal was drafted and implemented, had certain amendments made into the respective areas where it was Environmental Protection Act, Water Act, Forest Act, Air Act, the Environmental Protection Act and the Biological Diversity Act, where they made provisions specifically that after the cases have been tried by the pollution control boards under these various laws, they will then be sent to the tribunal for the purpose of further trial, which means the role of the local courts and the High Court is sidelined and the case now goes to the tribunal to be tried. The important cases under this NGT which have been tried and which have come out with solutions are, the first case which was filed was the Aditya N. Prasad case versus Union of India, where the building of a flyover in Delhi was questioned, but they sought to give environmental clearance before they allowed the building of that flyover, that it was necessary to maintain the flow of traffic in Delhi, which otherwise is overpopulated and the running from one place to another makes it difficult. Then comes the case of University of Delhi versus Ministry of Environment and Forests and Climate Change and others, where they allowed a multi-storied building to be built right next to the University of Delhi, which they said was posing a grave danger to the environment around. So the orders were passed against the Ministry of Environment and Forests not to allow that building to be constructed. Then the case of Jitendra Singh versus Ministry of Environment and others, where the building or allocation of lands for industrial units was prohibited because it was detrimental for the environment. The case of Pawa Plastics, where they allowed the industry to continue because it was, they stated, a mere irregularity which was questioned and the industry was found not to be creating pollution. The case of Save Mon Region Federation, where the case was that it was trespassing on the rights of the scheduled tribes. The case of Municipal Corporation of Greater Mumbai versus Ankita Sinha, where the role of NGT was questioned, that what is the role of NGT? Can it be considered at par with the High Court of any state? But it was stated that it is a special tribunal or a special adjudicating body which has precedence over other cases and other adjudicating bodies and courts to try cases specifically related to the tribunal, and then the case of Teki Tagi Tara, where it stated that the persons who are appointed as expert members in the various pollution control boards were not found to be adequate and appropriate. So it was stated that when persons are appointed in these pollution control boards, it should be done with due care and diligence, and to see that they are conforming to the norms and the laws. That will be my presentation. Thank you.